morning, Council. Welcome to the February 10th, 2022 docket of the Kansas Court of Appeals. I'm Judge Anthony Powell, and with me today are Judges Kim Schroeder, one of our senior judges, retired District Judge James Burgess is sitting with our court today. Last but not least on our docket this morning is the case of Cynthia Degand versus Stormont-Vail, case number 123526. For the benefit of the audience, could we have the appearances, please, first by appellant?
Thank you, Your Honor. L.J. Leatherman of the Palmer Law Group on behalf of appellant Cindy Degand.
And may it please the court, Stephen Mock of Goodell, Stratton, Edmonds, and Palmer appears for appellee, Stormont-Vail Healthcare, Inc.
Thank you, counsel, very much. We've set this case for 15 minutes aside. Mr. Leatherman, would you like any time for rebuttal?
I would, Your Honor. I would request 3 minutes of rebuttal.
Very well. You have 12 minutes. You may proceed.
Thank you, Your Honor, and fellow judges of the Kansas Court of Appeals. This is a true public policy issue that this court is going to be weighing. The simple concept is that there is a shield provided to property owners in the state of Kansas that recognizes they are not the insurer of safety of everyone who comes onto their property, and certainly not during a winter storm in Kansas. And the exact language of Agnew v. Dillon, where the doctrine arises here in Kansas, is that a business proprietor does not breach the duty of ordinary care owed to invitees to keep premises in a reasonably safe condition by not removing accumulated precipitation from exterior surfaces during a winter storm and a reasonable time thereafter, comma, absent unusual circumstances. It does not remove the duty to keep the premises reasonably safe. It removes the breach of the duty, which is typically a jury question. Whether a duty exists is a question of law. Duty does exist to keep the premises reasonably safe. And we've carved out a shield for property owners that says, while that is your duty, it won't be a breach if there are circumstances beyond your control, specifically here, a winter storm. The district court in deciding this said, I don't think the circumstances you presented are all that unusual. And individually, in different cases in different states, each one of these facts has not been determined as a matter of law to be unusual. We believe, the appellant believes, that this is turning the shield provided to property owners into a sword, creating immunity. The unique facts in this case, the unusual circumstances, is that it is unusual in Kansas when there's extreme inclement weather that all businesses will remain open. This court shut down last week and went from live arguments to Zoom arguments because the health and safety of the lawyers and the judges involved would be better served by moving to Zoom. We can do that as lawyers because we have Zoom. In a hospital setting, as we now know through the pandemic, they are essential workers. There is essential work which must be accomplished in a hospital, which cannot be controlled remotely because it takes hands-on care at the hospital, and those employees must go when other employees considered non-essential would not be required to come to work. Those businesses, our courts, shut down. So it's a little unusual situation that when the winter storm is this inclement, they're required. That's unusual. Which gets to, is it or isn't it unusual? And if that's the question, it's a fact question for the trier of fact. The second thing that's very unusual in this case is that the employer in this, because they're an essential business, has a plan to deal with inclement weather. Because you don't need a plan if you can shut down during inclement weather. You need one, and they had one in this case. The director of maintenance was well aware that the inclement storm was coming. He had 2 pallets of ice melt. He did not lack the ability to pre-treat these sidewalks. He was not out of time. He was not rushed. He made a conscious decision that he wouldn't treat the sidewalk. Is that an unusual circumstance in inclement weather, that an employee of a landowner has time to make a decision, has warning to make a decision, makes an affirmative decision not to treat a sidewalk, is not an undue burden on them? And we know it's not an undue burden because he told us it wasn't an undue burden. In other circumstances, it may very well have been an undue burden to salt that sidewalk because we didn't anticipate the weather. We didn't anticipate that people would be on that sidewalk. It's fairly unusual to know that there is a possibility that there will be ice on a sidewalk, and know for sure that there will be multiple employees utilizing that sidewalk, and that it will occur at 7 a.m. and at 6 a.m. to make the decision, although I have the personnel to treat that sidewalk, and although I have the material to treat that sidewalk, I will make no effort to treat that sidewalk because there's nothing they can do about it. I didn't breach because it hasn't stopped sleeting yet. That cannot be the public policy of this state. We have an employee, and although the district court didn't agree with me, because I believe it was the Connecticut case regarding employees, says that the mere fact they're employee does not an unusual circumstance. And I would agree, just being an employee isn't that unusual. What is unusual is that this employee had to be there during inclement weather. Most employers, as we now know, shut down during inclement weather, as we did in this court system a couple weeks ago. What else is unusual about these circumstances? What is unusual is to be in a position that you could be safe and choose not to be safe. And that's really where we take this shield, which is appropriate to say, we're not going to let people sue you. We're not going to let people successfully sue you during a storm unless it was not an undue burden on you, which is what the specific doctrine itself says, is that we are not going to make you the ultimate insurers absent something else. And here we have a lot of something else. We have about 18 hours of notice. We have the material to treat. We have the staff to treat. We have a plan on how to treat. And as explained by Mr. Miller, the director of maintenance, he was monitoring the weather over the night and knew that he had an overnight crew that needed to treat some of the sidewalks. Now, there's an emergency area that needed to be treated. There are sidewalks that need to be treated on there. He made the conscious decision that this didn't need to be treated. Is it reasonable for a jury to determine if his analysis was reasonable? It's appropriate for a jury to determine whether his analysis is appropriate, because it was not an inability. It was not an undue burden. It was not any of the things that the core of the doctrine goes to that arose in this case. My client is a long-term employee of Stormont-Vail. My client felt unsafe or concerned about her safety enough to make a phone call to her employer. And this is where it's probably just my blue collar heritage that brings this up. But when you work as an employee for a corporation and you ask if you have to come in and they say the beds are full, that's them telling you there will be action taken if you don't, that we won't feel better about you as an employee if you don't make the effort to get here. And she took that with her and made the decision, I have to go. The employer is saying, we never demanded it. I didn't say you demanded it. She felt obligated to go because she felt if she didn't go, it would be adverse to patient outcome, which she cares deeply as a long-term employee of patient care in Stormont-Vail. And she felt that that her employer had told her to come by not giving her permission to stay home. Am I right? Is the defendant right? I don't know. A jury can tell us if I'm right or if the defendant's right, but it is not as a matter of law clear that there is no breach of this duty. We're asking this court to set up or explain or help us understand that both so that people like Stormont-Vail know and understand what their obligation is, and so that clients like mine know and understand whether or not they'll be able to present their case to a jury in unusual circumstances. We need some definition of how this doctrine is going to be applied. It is our position that the district court, in applying this as a matter of law, took that question of fact away from the jury. That if we could present no unusual circumstances, doctrine applies. The district court treated it as almost like the recent trial of Kyle Rittenauer in the self-defense. We can only look at this moment. Does standing alone in employee-employer relationship change? No, not standing alone. Does having a maintenance plan for which you made a conscious decision not to act in the safety of your employees enough? That's probably not enough. Is being an essential employee just standing? No, that's not enough. We're saying the constellation of facts are sufficient to submit this to a jury. And the jury can understand the instruction which can be given, and that is that Stormont-Vail did not breach their duty absent unusual circumstances, and that question should go to the jury. With that, we are asking that this court reverse the district court's decision and give us some instruction as to what it is, how is a district court to determine what an unusual circumstance is, what the cases and mostly unpublished cases that have followed Agnew and in other states, is they say, well, this one isn't, and that one is, and this one isn't, and it seems to be them determining. We need some guidance to help us. We need to know how to apply the doctrine, because it cannot be randomly. Does this person believe that that's unusual? Does this one district court judge have the ability to say, well, I don't think that's unusual? And that can't be a consistent enough test for the laws of this state. And with that in mind, we're asking the court to give us that instruction and to instruct the district court on how to apply this doctrine. And we're also in that, obviously, we were asking for a reversal of the district court decision because we need instruction, and my client needs the ability to present to a jury these fact questions, which in the analysis, those all at this point at summary judgment must be viewed in the light absolutely most favorable to my client. They must not be viewed favorable to Stormont-Vail. They must be viewed in the light most attractive to my client. It appears to me I'm at my 3 minutes, and I appreciate your time, and I will reserve the remaining 3:13 for my rebuttal.
Thank you, counsel.
May it please the court. I appreciate Mr. Leatherman's words on shield versus sword. However, you may gather that I disagree from the analysis that he provides in explaining that to the court today. I have a few things to say regarding his argument, and I'll just run down those, and then some of the arguments we presented in the brief. The first thing that I'd like to address is Ms. Degand's job duties, and as to whether she's an essential worker. And I appreciate, we all appreciate the efforts of healthcare workers everywhere, but I don't know that that's the question here today for you. And I'll tell you why. Ms. Degand had the opportunity to stay home on February 20th, 2018. She'd done it before. She had called in and asked if the hospital was busy, just like Mr. Leatherman described. But she also testified that when she left her home in Mayetta and had slid off the road 3 times on the highway towards Topeka, that she thought about turning around and going home and calling in and not going to work that day. That doesn't sound to me as though she was under some great concern that she was going to have her job affected. The other thing, she had stayed at home. I believe I said that she'd stayed at home in the past during inclement weather. She did not feel that she was so essential that she had to go out in this storm and drive all the way to Topeka. We know that Walker versus Memorial Hospital, that's cited in Agnew, which provides the basis for the winter storm doctrine in Kansas, says we are all under the obligation to know what we're doing when we go out into a winter storm. And that applies to Ms. Degand also. She knew that when she slid into work, right, into the parking lot, that once she got out, she was going to have to navigate that just like you or I would, going to work or having a Court of Appeals argument or wherever we are. Ms. Degand had the opportunity to provide authority before the district court. This same argument was made there. Excuse me. This same argument was made before the district court. She was able to provide authority then and was able to find none. I should correct myself. She found one from Indiana, which does not follow the winter storm doctrine or a like doctrine. So that authority was not persuasive or applicable at all. So there's been no authority on essential workers or job duties in and of itself as an unusual circumstance. The other item I want to address right off the top here is the idea that Stormont-Vail's weather plan or snow and ice removal somehow creates a higher duty than is set out in Agnew or any of the cases that follow it. There is no such higher duty. If you have, we want to encourage employers to have a duty to do, excuse me, I misspoke there. We want to encourage employers to try and do what they can if they're able to during a storm. I think we all rely on that when we go to the hardware store or the grocery store. We see the maintenance people throwing out the ice melt. I'm so sorry. Excuse me. But we know that the whole point of treating the sidewalks, that is not in and of itself enough to create this higher duty. I'd like to point now to a case that's not in the brief that this court decided in November 19th of 2021. It's entitled Lacoste versus Boot Hill Casino and Steve's Welding. It's an unpublished opinion of this court. In that case, the plaintiff fell in the parking lot at the Boot Hill Casino during a multi-day winter storm. And the court goes through several cases that are in all of the briefs, basically, before this court. And it actually, the plaintiff argued that she had detrimentally relied on the fact that Boot Hill made some effort to clear the parking lot before she fell. And this court found that her argument failed on the merits and that absent unusual circumstances, the defendants owed no duty to Lacoste to keep the parking lot clear of ice during a winter storm until the end of the storm and reasonable time thereafter, because anything else would be beyond reasonable care. And so the court concluded that if Lacoste, if her assertion was correct, that Boot Hill could be liable simply because they tried to clear the parking lot during the winter storm, then no business would ever try to keep its premises clear during inclement weather. So this court has looked at this question and the idea of, even if there was a policy, that it does not create a higher duty and that we're still going to allow the winter storm doctrine to do its work and to have all those people that choose to go out during the winter storm to be on their, have to assume that risk that they are doing it during the winter storm. I did cite to a case in my brief. I really liked it on this particular point. And that was Cash versus East Coast Property Management. That's out of Delaware. I do cite it in the brief. In that case, the plaintiff asserted that unusual circumstances applied because the defendants had a snow removal policy. But that court disagreed and cited Morris versus Theta Vest, again, which is cited in our brief, that it is reasonable conduct to wait until the storms end. And this is true whether successful or vain efforts to take earlier action occurs. Even if the defendant does have a policy to remove snow and ice during the storm, without more, it does not constitute the voluntary assumption of a legal duty. And the absence of that legal duty to remove the icy conditions renders moot the question of whether defendant exercised reasonable care when they were attempting that removal during the storm. I think the overarching question here, or said differently, the overarching decision by Ms. Degand was that she has conceded that there was an ongoing storm. That puts us in a whole different ballgame with regard to the unusual circumstances doctrine. All of the case law that I have found shows us when there is an ongoing storm, we're not in the unusual circumstances doctrine, in the unusual circumstances exception, particularly in the Connecticut case law that plaintiff pointed to, appellant in this case, that no, we're not going to do that. It requires, in both Cooks and Hansen, they talk about whether the storm was lightning, again, whether that ongoing storm was still going, and a lack of alternate means of egress. They said, no, you have to have both questions of fact in order to get to the jury, which is what I think the argument here is. In the light of the fact that Ms. Degand has said that there is an ongoing storm, we take it out of some of those absent, something that honestly we don't have here. There are no facts here on that. I want to highlight just the idea here before I wrap up that Ms. Degand has alleged a number of things in her brief that do not have evidence in the record on appeal. There is nothing about the fact that she was told to come into work. There are no facts that she was required to park in a certain place, go in a certain door, any of those types of things. So I would encourage the court that in our brief, we have taken on all of those and shown that to not be consistent with the record on appeal. Here, whether there exists the duty or the application of the winter storm doctrine is a question for this court and not one for a jury. Here, the winter storm doctrine applies that Stormont-Vail did not owe a duty to Ms. Degand to clear the ice during the ongoing winter storm. We would rely on our brief as well as the case that I cited of this court, Lacoste versus Boot Hill Casino. And we would ask that you affirm the district court's ruling in this case. And with that, I thank you for your time.
Counsel, thank you very much for your argument. Mr. Leatherman, you have 3 minutes.
Thank you, Your Honor. I apologize for the interruption of sound. That was my timer that I thought I shut off at 12 minutes. But very quickly, because there's a lot to cover, language is really important. Appellee's counsel keeps saying there's no duty. There is a duty. The question is it a breach of the duty during the time frame? And she makes a very big deal that it was ongoing. It says right in the doctrine, from exterior during and a reasonable time after, that it's not a breach, and breach is a jury question. This court, there is a duty to keep it reasonably safe, but absent unusual circumstances, that duty is not breached. There are unusual circumstances here as highlighted before. Second, the lacrosse case, counsel uses an interesting term. that trying to do it, absent something more, does not take it outside the doctrine. We have something more here, a conscious decision not to treat the sidewalk. It wasn't that they tried and failed. It's that they said, we're not going to do it. We will protect these sidewalks, but not those sidewalks. That's the something extra. Here, council said, I don't think if you know it's really dangerous and you've gone home before, but continue on to your job, sounds very much to her like that's being forced to go to the job. Two important parts of that sentence. One, I think. She probably does. I believe her. I think it absolutely shows it. That's why we need a jury to determine which one of us is right. If we're dealing in I thinks and I feels and I believes, that's something that juries need to determine. It sounds to me very much like she was afraid of losing her job, very much like she wanted to be safe, but chose her job over safety because she trusted Stormont-Vail, that when she got there, she would be safe. Turns out that trust was misplaced. The higher duty language that council keeps talking about does not create a higher duty. It says the duty is to keep it reasonably safe. That never changes, but you get a pass during a storm absent unusual circumstances. It's plaintiff's obligation, here appellant's obligation, to bring forth facts that make it unusual. And what is so unusual about this case versus any of the other cases that did not find that it was outside the doctrine is that we have sworn testimony by the maintenance man that he decided not to treat it, that he didn't want to, and that he had the people to do it. He had the resources to do it. He had the time to do it. And just he decided that he didn't want to do it. And that kind of attitude cannot be what we look to in this state as non-negligent. He had a duty. He had a free pass if he couldn't get to it, but he can't look at it and say, I consciously am going to ignore the safety of the employees at Stormont-Vail. Because had she been 100 feet further, she'd be covered by work comp, but she wasn't. So from her truck to the door, she doesn't have any protection from her employer. In that space, are we going to give them a free pass when they make a conscious effort to ignore safety and not treat that sidewalk? Thank you.
Thank you very much, counsel. We appreciate your excellent arguments. We will obviously take this case under advisement. We'll issue a written opinion